I'll call this meeting of the ZBA Board for June 18th in session at 7:12. And we're going to start a new tradition, hopefully on this board. We're going to, every ZBA meeting, salute the flag. Please all stand. Pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay.
I think Mr. Carr should salute properly as a colonel in the Air Force.
He's not in uniform. Doesn't he have to be in uniform?
I don't know.
What did you just accuse me of?
Nothing. He said he thought you should be saluting the flag where you're a colonel.
I'm not in uniform.
That's
You're
what I
right.
said. He's not in uniform. Okay, let's see here. We're going to do review of the minutes. And let's start with the, oh, I'm sorry, you're correct. Roll call. Scott Crumley is here.
Yeah.
Roseanne Quacks is no longer an alternate. She's actually been sworn in as a full board member. Peyton
Congratulations.
Carr,
Yep.
Vice Chair Richie Shelton, Chair Dana, and our Enforcement Officer Dan Vincent. So all present and accounted for. Okay, thank you. Let's review the minutes of 3/12/07. We'll take them for a month. And do I have a motion to accept the minutes of March 12th?
Motion to accept the minutes as.
You can, or you weren't here.
I wasn't here. Thank you.
Yeah, only members that were here, yep.
Yeah.
And I believe,
I'll make a motion to accept the
It's
minutes of
waiting for
March 12th.
okay,
I'll second it.
okay, any corrections?
None that I
I
have.
didn't see any.
Okay. All those in favor, raise your right hand.
Aye.
Aye.
Aye. Okay. The minutes for May 21st. I have an extra copy in case somebody doesn't have a copy.
So why?
Okay. Do I have a motion to accept the minutes of May 21st?
I'll make that motion.
Second.
Any corrections?
Yeah. No, I wasn't here.
Did you say you had a correction? Or you didn't?
No,
Oh,
I
okay.
was absent at that.
All right, okay. All those in favor, raise your right hand. Aye.
Aye.
The minutes of June 4th. Do I have a motion to accept the minutes of June 4th?
Motion to accept the minutes of June 4th.
Do we have a second?
Yeah, I'll second him.
Any corrections? All those in favor signify by raising your right hand. Aye.
I abstain, I was absent.
Okay. I'll accept it. No correction. Good job. Okay, a regular business meeting. We have before us this evening, 2 Bennett Way Realty Trust, continuation of the appeal from administrative decision. The applicant has asked for a hearing regarding a decision by the building official to deny their request for an extension of a building permit for a 22-unit apartment building originally obtained on January 13th, 2006. The property is located at 2 Bennett Way, tax map U4, lot 4-11. It's in a B1 zone. At this point, I will request that Mr. Dan Vincent give your reasonings for the denial.
Just a quick point of order, you stated it was a 22-unit. It states here it's a 24-unit.
Thank you.
Mr. Chairman, if I might, this board is appearing here this evening not as the zoning board of adjustment, but as the building code board of review in actually determining if the decision that I made was in compliance with that code. The issue before the board this evening is in reference to the code, which is the state building code, which is also the code that has been adopted by this community. The specific question that will come before the board is, was there an error in my interpretation of the code in denying the extension for an additional 180 days from the applicant? The authority for this zoning board to act as the building code appeals is granted by the building code as well as the state RSA. Some of the information, Mr. Chairman, if I can give to you for review, is from the International Building Code 2000 edition, which the town has adopted. You'll see this highlighted area there, which is relevant to this evening's presentation and appeal.
Okay, I have one question on this, Mr. Vincent. Would there be any reason why we hadn't received this prior to this evening?
Well, this is part of my presentation, Mr.
Okay,
Chairman,
sure, presentation, okay. Thank you.
for the board. And I thought it best to be, seeing as this was our first meeting, rather than being the zoning board, to realize that we're actually the Building Code Board of
Okay.
Appeals. As you see, in opening of the first page, under section 104, the duties and powers of the building official, the highlighted area indicates my authority, indicating the building official shall have the authority to render interpretations of this code. If we turn the page, you'll see at section 105.5 on expiration is that the extension shall be requested and justifiable cause demonstrated. The request was made for an extension, as it had been previously on 3 other occasions, for an extension to the permit itself, which I granted. The reasoning at that time, I believe, was specifically that there were economic conditions that were not sufficient for the owner or builder to move forward with the project. At the last application that was made, and the reason that we're here this evening is that on that application, which would have extended this final request into the 2-year period, I did not see that the economical conditions would, that the economic conditions were not demonstrated, I guess, in the request, nor did I feel that the economy was in such of a condition that the permit should have been extended. The first 3 occasions, I think, is a reflection on this community's and in my attempt at satisfying the needs of the community. I think on the 4th application for extension, that kind of attitude might have expired because we were going into the a 4th round of requests for the permit itself. And I did not see at that time that the economy was a legitimate reason to grant the extension of the permit. I also don't find the economics to be relevant to the building code. If this project was to come along and the applicant were to say, well, we're asking for another extension because the company that we were doing business with, for unfavorable reasons, had to close their business. Or there was some additional considerations we had to make in any issue relevant to the code. Maybe a code had changed that they may had to have complied with, and it changed their engineering plans. Those things weren't what was mentioned in the request for the extension, and therefore I denied the application. As a result of that, an appeal was made, and Attorney Bolt is here this evening representing the applicant on a attempt to reverse the decision that I made. In order to reverse that decision, it has to be reversed by 3 board members. In order for that decision to be reversed, you have to find that I was in error in making that decision not to extend the application. And I think in the pages that I passed to you, at the expiration, at 105.5 was where I found the authority to deny the extension of the application.
We also have received a legal opinion from our attorney. And I think all the board members have a copy of that legal opinion. And if I could, first of all, let me ask this question so the public knows, because the public doesn't have the documentation that we have up front here. We should all be talking to our mics. Your reason for denial, well, first of all, they asked for an extension. And what was the reason for the request for the extension?
Basically based on the economics of the time.
Okay, so that was a continuous request. Every time they requested an extension, it was always based on economics.
Yes.
So the reasons never changed.
Correct.
Okay.
Which I
And,
approved on the first 3 applications, but refused on the most recent.
okay, and most recent one, because at that point you've, I don't want to put words in your mouth, but it would appear that you felt economic conditions were not a justifiable reason.
Not a justifiable reason and not an issue that was discussed in the codes. And again, I think it was my attitude representing the community, an effort to work with the general contractor in furthering the project.
Okay. Our attorney is Peter J. Laughlin.
Laughlin, yes.
Laughlin, okay. We received a memo of June 1 of '07, in his opinion, which is we requested. You have asked my opinion as to whether you have authority to deny a request for further extension. It is my opinion that you do. Section R-105.3.2 and R-105.3 of the 2000 International Residential Code for 1- and 2-family dwellings grants you the authority to grant 1 or more extensions. The code obviously was designed to give you discretion in this matter. The code requires that the extension be granted for justifiable cause demonstrated. The purpose of the code requirements would appear to be to avoid having stale building permits existing in the community for many months or even years. It seems to me that you have exercised good faith by issuing 3 permits, but were not under any obligation to issue those and not under any obligation to issue any additional permits. It is your decision as the building inspector as to whether justified cause has been demonstrated. Obviously, any decision of yours is subject to review by the Planning Board of Adjustment. So I'd like that to be noted. At this point,
Just to make a couple corrections there, Mr. Chairman.
sure,
Referenced in that letter was the International Residential Code.
yes.
It should have been the International Building Code.
Okay, International Building Code.
And the sections that you described, I think, should have referred to 104.1 and 105.5.
So replace the R-105.3.2 with 104.1?
104.5.
Okay, which one are we replacing here?
105.32 is replaced by 105.5.
Okay. And the other one's okay?
What is that number?
105.3.
3. No, that's in error as well. I think 104.1 and 105.5 would be the,
Okay, you all
Items.
have that for
Mhm.
corrections?
We don't have that
We don't
letter.
Have the letter. that-
We don't
No.
have that particular letter.
You should have all received this letter. It was mailed to you at my request.
it was,
Yeah, we got that.
as far as I know.
Yeah.
You and I
No,
got
this
it.
is the one we got. Just this one here.
That is the same one.
Yep.
But I'm missing,
On the second page.
Yeah.
the second page I'm missing. It goes right from 1 to 3 on mine.
So is mine.
Okay, we need to get him a copy of this
Yeah.
one. It's on page 2, all right.
Charge of stapling in your office.
This, the automatic stapler. Would you like me to make copies of that for the board this time?
Yep, okay, good. And at this point, are you all set on what you have to say? So we'll have this,
Yep.
the applicant introduce himself? Okay, and who's here to represent the applicant?
For the record, Mr. Chairman, Chris Bolt of Donahue Tucker Chandela, here for the applicant. If I can, since you've read the letter into the record, I'd ask for a copy of that be provided to me as well,
Can we?
of the full.
Do you have the full letter there?
I have the page.
That you read.
I don't have anything. You haven't given me a
Oh,
copy.
okay.
Yeah.
Thank you.
Should I wait to do this?
Yeah, why don't you wait?
Do you
Yeah.
mind?
Not a problem at all. We can get it afterwards.
Yeah.
As long as you have it this evening.
For the record, again, Chris Bolt, the applicant, 2 Bennett Way. We are here, whether you are sitting as a building code board of review or the zoning board of adjustment, you are here in the guise of reviewing this appeal of an administrative decision. I agree with Dan's comment that it takes a vote of 3, just as it takes on any vote for the ZBA. But what is not been mentioned yet is that we're dealing with a $10,000 fee. A $10,000 fee that was paid based in your format of $5 per thousand of a $2 million project. The code and your regulations give no guidance on how the code enforcement officer is to apply his discretion. Therefore, you, as the board, are the safety valve. You are to evaluate the facts, the circumstances, and the reasons given, and see, in your eyes, is it a justifiable cause in light of the circumstances? You have in front of you a copy of the plan. That plan is number D34101, which was signed by the planning board in August of '06 and filed a couple days thereafter. This project is for the construction of that 24-unit building there to the south end of that project. As you, some members of you may well recall, this was a project that appeared before the ZBA on a couple of occasions and took some time to get through the planning board. What has occurred on the property is that which was required by the planning board to occur within that first year. That is the takedown of the old 24-unit building. What it was expressly delineated by the planning board is that my client had to complete within that 4-year window from the approval in November of '05 the framing and roofing of that new 24-unit building to gain the vesting protection of RSA 674-39. Obviously, the first part has occurred, so we are satisfied that statute's 1-year requirement, and the 4-year window has not expired. There is no difference in what's on the ground now and what would be coming forward with a construction plan now versus had we waited to apply for the building permit till next year. You know, there is no difference. I have discussed with Dan one of his concerns, which was there had been a code change in his eyes. And we wanted to be very clear to this board, as we were with Dan. We are more than happy to be extended so long as we comply with the current building code, which I believe is a 2005 version. So there is no harm to the town that is being prevented by the upholding this denial. However, there is harm to my client, not only of the $10,000 amount, which in essence becomes a windfall for no apparent reason to the town coffers. We have, the building permit is really only for the foundation. For whatever reason, the dollar figure, and we do not have in the file, although Dan said it did exist in the file a couple weeks ago, the actual permit on how that dollar amount was calculated up. Because from our eyes, the foundation work is really only about, I think the contractor spoke with Dan last week or so, less than $30,000. So the fee should have been $149,000. We have a $10,000 fee that we did pay back when this permit was initially obtained. And to go through the chronology, that permit was issued on January 13th of '06. There was the first request for extension, and if you have my packet, these dates are all borne out through that first page of the my material on the appeal. The first request for extension was a 180-day request, tendered on June 12th, '06, before the expiration of the original time period. And that request was based on the phrase, "We have not yet been able to begin construction." Right? That's not necessarily an economic reason, that's just a statement of fact. That extension was granted not for 180 days, but Dan gave us only 90 days. We don't necessarily get a reason of why it's the halftime. That extension, however, was granted on June 19th, '06. Our second request, in compliance with his past dealings, we asked for only 90 days. Second request was on September 25th, '06, and there the stated reason is escalating mortgage interest rates causing additional expenses and delays and the volatility of the oil sector. As anyone knows, does anything in construction, and frankly now any business, how much our economy is driven by the price of oil, how much it is driven by the interest rates, which are affected by the price of oil. And this was something that had, we were viewing escalating costs. We're trying to get a handle on things. That second extension was granted for that stated reason, for 90 days on October 2nd, '06. Again, before the end of the expiration, on December 26th, 2006, we asked for the third request of 90 days. They are stating fluctuating mortgage interest rates causing additional construction-related expenses and delays, and the volatility of the energy section causing extreme price fluctuations in almost all construction-related materials. So, in essence, the first is different. It's a pure time frame. The second and third are similar, talking about the economic factors that are driving the costs and delays that we are experiencing in pricing out this job. We have that third request on that language granted to us on January 12th, 2007. A fourth requested 90-day extension is filed on March 21st. That is the one we are here before you. That one of March 21st, 2007, uses the exact same language that was previously deemed a justifiable cause by Mr. Vincent. It is similar to the same reason that was deemed a justifiable cause when the second one was granted. But now we get a denial. The denial is dated April 2nd. It is mailed to us on April 9th, and I filed this appeal within the 30 days of the April 2nd date, so that we have the jurisdiction of this board to act as the necessary constitutional safety valve. With all due respect to Dan, I understand that he didn't feel comfortable making that call at this stage. He wanted to have the protection of this board in making that decision. But there is no definition of justifiable cause in the code, in any case law, in any treatise, including Peter's books, and there is nothing in your ordinances. What I posit to you is that because the reason stated in our last one was deemed justifiable cause by definition of Mr. Vinson's actions, it is still justifiable cause, at least for this project. Whether you wish to do this in other projects, saying, look, that's not something we want to continue to do on other projects, great, fine, and wonderful, go forth and conquer. But for this project, we've got a $10,000 ticket out there. And there's no reason to punch the ticket, to say we can't continue to go forward, especially if the rationale was there's been a change in the code, I don't want to have you be on the under. We are more than happy to have as a condition of the approval that we have to be under the then current. If they change it again tomorrow, which Dan and I have discussed, we don't anticipate it changing for another couple years. But whatever the current code is when we come forward, that's the code that applies. So from a standpoint of how will a court look at this, I present to you it will look at the town's own conduct in this case. The lack of definition of justifiable cause in any, whether the building code or in your own regulations, and say it's arbitrary and capricious to change your mind midstream. The folks get to keep their building permit. So long as they're, our issue is we've got to build the thing before that expiration of the 4-year window. That's your confirmation that we're serious. Because otherwise, my client has to go back through more than 18 months of planning board processing and ZBA approvals of this case. We don't want to do that. Trust us, we don't want to do that. We have every intention of getting this building built as soon as humanly possible. This thing had some unique features, shall we say, one of which was we worked out the deal with the financing, and there was a lot line adjustment with some of the Cheney property to give us a straight lot line. That created all sorts of cross-collateralization issues for the Cheney, more than you need to be concerned with. But what we do have is an approved project. What we do have is a $10,000 payment that has been made. And what we do have is an arbitrary decision if you allow it to uphold. I'd be happy to answer any questions.
Chair will recognize.
Is there any problem?
Chair will recognize you.
Is there any problem with us charging them on the permit for the amount that they paid for the foundation and reimbursing them the rest?
That, in fact, is that question directed to me?
Yes. I will.
Whoever can answer it.
I've had that discussion with the building code enforcement officer here, and first of all, I want to say I was never under the impression that the money was ever in question. It is actually the denial of that permit is what's really in question, because my understanding was there was never any money. The money was there, and you tried to work out a deal to pay back some of that. So I'll let Mr. Vincent answer
happily
that
respond.
question.
Realizing the plight of the applicant, and again, the town certainly is not looking for a windfall, and in all fairness to the applicant, the proposal was made to the applicant's attorney that the town would credit $9,850 for the future application of the building permit. And I agree with Attorney Bolt that we did receive a check for $10,000. That check was anticipated that we were going to shortly receive the full set of building plans, which we did not. So the permit was only issued for the foundation, which, from discussion with Pilot Construction, the general contractor, amounted to $150 in permit fees. My suggestion was that the town keep the $150 and credit the $9,850 to the future permit. So at no time was the $10,000 in jeopardy to the applicant. Simply the $150, with that balance being applied to the full permit when full plans were delivered for review.
And is, if I may, Mr. Chair, ask Mr. Bell a question? And is that fair? Does your client feel that that's a fair situation?
Actually, let me
Okay.
respond to the first part.
Okay.
It was only if we would accept that the existing permit was validly rescinded. Otherwise, the entire amount was on the table, in jeopardy, shall we
But
say.
why-
And what my concern is, when I have a valid permit and I say I'm under the existing current building inspection, I don't know why I don't have a valid permit. So that I'm concerned with what am I mean, I'm mirroring image Dan's future fear. Dan was concerned, I think your phrase was, you're in a closet and there's no light on for, you don't know what's going to happen in the future. Well, we're the same way. We have a permit. We have asked for an extension. We are, it looks like, entitled to the extension because we've gotten it in the past. And we see nothing that we have done wrong in why that permit cannot go forward. Accordingly, I think we're at the same place. It's just whether or not you're saying the permit's gone. Again, I can't find, sorry to keep using the same phrase, a justifiable reason for why it should be gone.
Ignoring the justifiable reason as to why it's gone, if the town's willing to hold in, however they hold it in escrow, whatever, the remainder, you just stated that you have every intent of building. And if the town is willing to put that money aside and put it towards when you're ready to build, what is the problem if they invalidate your current permit? I don't see why that's such a big problem. You plan on building before the vested rights are null and void.
Correct.
And the money's going to be sitting there waiting for you.
I guess from a standpoint of when I have a permit, I'm always concerned when I lose that permit. I don't have I can't see a reason for it to go away, nor do I know all avenues in the future if, not to say that Dan would ever do this, is there something that, my limited resources between the years will come forward and not have thought of that Dan can use to block the permit in the future when we come back in?
I'll just make a statement. I don't see any reason to expect Dan or to even state that he would do something like that, when it's obvious with the extensions he's already granted you that he did it to be fair, like he stated, and like the letter states, to try to help a developer out. Someone came before him, needed an extension for what probably isn't a valid reason, and he, being a good guy and having good intentions, extended it 3 times. Now, I'd hate to see him not want to do that for someone else that comes in town. But to make that statement, I think, is unfair to Dan, and I yield
And
the floor.
I'm not meaning to cast aspersions at all on Dan. I'm saying I don't know all of the possibilities that are out there, but I do know how to play the game with the permit remaining. That is for the foundation. That the current code, the 2005, is what
2000.
would apply, excuse me?
2000 code we're in now. For the record, the 2000 code.
I thought it had been updated, you and I discussed that it had been updated more recently.
2006 code will be coming before the council for review for adoption.
Okay, but it hasn't been adopted yet?
Correct.
Okay. Well, I guess the bone that I would have to offer is allowing the permit to stay in place. We would have the 2006 code applicable to it once that is adopted. But I'm always leery of giving up any right, Ms. Quawks, just from a standpoint of I know how to protect that right. I don't know necessarily what may or may not be required to get that right back if I allow it to lapse. And the monetary situation was I had to take it or leave it, come before the board. I am thrilled to hear that, the board's discussion on that amount, but I think it comes back to a fundamental issue of how do we define, with the lack of definition of both the building code and your ordinances, what justifiable cause is in light of the action of this file.
Mr. Payton, you had a question?
Yeah, so actually, it's a statement. My feeling, first off, I understand exactly what you're saying. I mean, I understand your concern, but I also think that the fact that Mr. Vincent used a reason for granting an extension does not mean that reasoning should be held because the economic times are different for each time that the extension was requested. So to be able to say, well, you've granted it 2 times before, why shouldn't you grant it now? Well, we've just gone through a 90 or 180-day period. Things are not the same. And for whatever reason, I think he has reason to change his mind. I mean, justifiable reason. If that's a legitimate basis for granting or not granting an extension.
I would also like to add something to that, too. One of my concerns was, and I was really surprised when I read it in the attorney's opinion, was here it is. The purpose of the code requirement would appear to be to avoid having stale building permits existing in the community for months or even years. Now, your concern is, I can fully understand your concern, absolutely. And if you're worried about what you would have to go through if you were to have to come in and get another permit, Mr. Vincent would have to follow the rules or the regulations of whatever that was required for a permit at that time. So he'd have to follow those same rules. I'm concerned also, as I guess I'm hearing the rest of the board saying the same thing, is that I just have a real problem of granting extension after extension after extension when it's the same reason every time. We don't know where the economy is going to go from now for another 6 months or 7 months, 8 months. We have no idea where it's going to go, and neither do you. But to continue to grant extension over an extension and again, I can understand why Mr. Vincent is doing what he's doing.
And that's why I am trying to overcome that concern
Right.
by stating, in essence, we're not stale.
Mm-hmm.
If we're saying we will be if the council adopts 2006, we're in under a 2006 as a condition of this approval. Accordingly, you're not out anything, and I'm not even out the 150.
Well, we're not out of the revenue or anything, but we're setting a precedent, and that's what I'm uncomfortable with. We keep on doing this and doing this. It almost appears that, and I don't want to put words in your mouth, but it almost appears that you probably weren't ready at the time for that $150 per permit that you paid for, perhaps if it had been a little bit further away, we wouldn't be where we are today.
Hindsight is always a wonderful teacher.
This is true. I'm going to let the Vice Chair speak here.
Yeah, you know, when I review all of this, it looks like they abided by the decision of the planning board. They did active and substantial development. They took the old building down within the first year. They've got 4 years to complete it. So what's wrong with extending the permit? It says the building official was authorized to grant in writing one or more extensions of time for periods not more than 180 days. After their 4th year, they would automatically lose their $10,000 if they didn't have their building up and roofed.
But the $10,000 is not in question, it's related to $150. If the
No.
permit is denied, they have to go and apply for another permit of $150. No?
I don't see no reason
that
why
correct?
they just don't extend
If
the
they're
permit.
denied?
The denial on this appeal?
Yeah.
The denial on this appeal, in my estimation, would only affect the $150 for the foundation permit.
In other words, we would keep the 150.
Right,
They
that's
get
what
the
I'm saying.
balance. They don't have to pay another 150.
For the,
Well,
If they came
Yes.
back for
And
another
then
one, yes, they
he-
would.
Then
Because
he
it
would
would-
have to reapply for another building.
Right, and that's what I'm
permit.
saying, if they weren't ready at the time, and we keep on giving these extensions, and again, I understand where you're coming from,
I think he's got up to 4 years.
he has within certain aspects of that. Ms. Quacks?
Now, I understand, I'm hearing 2000, I'm hearing 2006, the council's going to look at accepting the 2006. In your estimation, Mr. Vincent, the difference between the 2000 building code and the 2006 building code would cost the applicant how much more? Because there's, I'm sure there's updated, there's more restrictions, and there's more safety issues and so forth that you have to build. So in my mind, I see somebody who has 4 years to build is going to come in and get a building permit, knowing that there's going to be a change, so that they can have that building permit for 4 years, insist on extensions, and save lots of money by having a permit before the changes were made, therefore saving money and not having to comply with new codes. And that is a precedent that this board should not begin with.
I think that's a reality, it's a fair thing to say, because the 2006 code certainly looks at other life safety features that the 2000 code does not look at. Probably, if we were to examine that 4-year period, that possibly that the permit fees would change. As far as the code, the permit and the approval of the permit would reflect that year that the permit was initiated in. So at this time, the permit that the applicant has is under the 2000 code. To return at a later date until the town, if they do decide to do so, adopt the 2006 code, they would be still under the 2000 code. Once the 2006 code is adopted, that permit then would be under the 2006.
if it's adopted.
Right.
So
Right.
Okay.
that's not
Right.
a concern. Shouldn't be a concern.
Is that in writing?
Well, it's
Well, I've
he
stated it on the record, so
is.
it's
It'll
on,
be
you
in the
know.
minutes.
Okay.
Let me have Mr. Quinley, Scott Quinley speak. Did you want to speak to this? Did you have your hand up earlier?
Yeah,
And then we'll let Mr. Foster in the back speak afterwards.
what is the disposition, since I haven't read it in the paper, of that check for $10,000?
That's been deposited into the town's accounts.
Town's general account?
Within the zoning, yeah, in general account, that's where it goes, but it's earmarked for, specifically for this entity.
It is.
Just to clarify why that check was in the amount that it was, is because we were to receive building plans for the project. And that's why the general contractor paid that amount. And as of yet, we have not received the plans.
So rather than give the money back, we're gonna hold it, it's sort of like, as Ms. Quack said, some type of escrow. So in the future, when they do decide to come forth with the plans, the monies will already be there.
Why can't we just give them the money back?
Why can't we give them the money back?
We could do that as well.
Just give them their money back? Keep the 149 for the
But he
foundation,
doesn't
and
want
that's it?
that. What, can I ask you, how would you like to come out of this?
In the perfect world, My permit stays in place, ideally, until the 4-year window lapses,
Okay.
with the understanding that if the town adopts the 2006 code, we apply those regulations. Thereby, the money stays in the town coffers. You don't have to give us back anything. That's the perfect world. I recognize I don't live in a perfect world all the time. One concern we obviously have is the general concept that economics doesn't matter. Now, economics have to matter. It's the bedrock of what we're doing here. And obviously, the energy sector influences construction costs. That is, it's like throwing Jello at the wall right now to get construction costs nailed down with folks. You're experiencing it individually when you're trying to pre-buy your oil right now. Look at whatever the rate you're getting in the mailers from your company. So it is obviously a factor, and we have seen nothing, in all due respect to Dan, that can dissuade us otherwise. There's no evidence that doesn't apply. There's no evidence that it's not to be considered as a justifiable cause. There's no case law that deals with this subject. I can't find any even in other jurisdictions. What we're dealing close with is just cause that the courts deal with all the time, and that is straight to a balancing test. What is the harm to the folks that are trying to avoid it? What is the benefit to the folks that are trying to gain it? How do you weigh this stuff? And that's where you, as the board, are the safety valve. And I'm saying Dan hasn't expressed it to me, I haven't heard it tonight, of a downside to the town in light of the fact that we're saying if the town adopts 2006, we're willing to play by 2006.
A question just out of curiosity. What is the 4 years a common period given to complete the project?
The 4 years is the world of the planning board, what's called the vested rights.
Okay.
Under 674-39, you have to hit 2 hurdles.
Right.
One, you have to have active and substantial development within the first 1-year window
Right.
to say that you are a live project. And then you have to have substantial completion within the 4-year window to be protected in perpetuity going forward from any zoning changes, amendment to the site plan regulations or subdivision regulations. You, in essence, get the Maxwell smart cone of silence dropped over your project. You don't get toyed with anymore. But you have to meet those 2 hurdles. The biggest case where the issue came into play recently is the AWL versus City of Rochester case. You may have seen in your ZBA packets. I know I talk about it when I lecture for the LGC or the OEP. It's what you look to for that balancing. And there, it's not a dollars and cents. It's what was required for the project. Here, now, the statute's changed so that you're supposed to define it in front of the planning board. And that's what we did in this case. So we have the takedown of the 24-unit building is the definition of active and substantial development in the 1-year window, and roofing and framing of the new 24-unit building is by definition what we have to do within the 4-year window to be vested.
Go ahead, I'm sorry.
Okay, I'm trying to get spun up on this whole thing.
Sure.
This whole idea of having 4 years to complete, I mean, if you're building a 60-story skyscraper and whatnot, I can understand how 4 years or the big dig or something like that. But for something, now come on down, now you're talking about a 24-unit, it could be almost anything. But the idea of having 4 years seems, to me, somewhat unrelated to the actual construction, the time it would take to complete the project.
Positively.
So it's building into it some of these unknowns to decide, so you can decide whether you want to go in the beginning of the 4 years or want to delay a little bit, so it's giving you some time to.
Correct. And as was indirectly commented here, we wouldn't be here had we waited until now to file the initial permit application. be a non-issue. We'd have the original 180 days. And also, if 180-day extensions were granted originally, we wouldn't be into the third one yet. The original one would have done and the second one would have done, and we'd be out a little bit in advance of what we are now. So don't let the numbers of requests overly sway you to say I've used my tokens when my tokens were kind of cut in half by the length of time granted to us originally.
You are correct. There are no limits to how many extensions can be granted. However, we do have a legal opinion that says exactly what, that's what I want this board to understand. Also, we do have a legal opinion here who does support the code enforcement officer here. When 180 days is granted, what do they expect them to do in that 180 days? Is to get that foundation in place? Is that what this?
No, I don't think there are any expectations. But if I might, Mr. Chairman, if I could comment to,
Okay, we have a sidebar here.
if I could comment, the question here this evening is not whether or not the $10,000 is returned to the applicant. The question is not when or where they start this project. The question before the board this evening is the strict letter of the law. Who has the authority to make the decision? The code places authority to my authority for the interpretation of the code. It also places that authority to be willing to accept or not accept the reasoning for the request for the extension. I denied the request for the extension, but did offer a way to resolve this, which would have meant that the applicant would have lost the foundation permit only. So, and I think that, looking at the strict letter of the law, that's what is before the Board of Appeals here this evening. Not whether or not we go by the 2006 code, not whether or not the money goes in escrow, not whether or not the money is fully returned, but we're dealing strictly with the two issues that are within the code, as far as the authority goes and as far as the decision makes on extending the permit. And I think that's what we should focus on.
Do you have a question?
Yes, or one comment to follow that up. Because we don't have a stated reason for the denial other than it's what you used in the past is no longer good in my eyes. It's an amorphous rationale. You actually have, by definition, an arbitrary decision. My concern is that do not think, no matter who sits in the chair, and Dan does a very good job, but no matter who sits in the chair, they do not have absolute power. They are a public servant. They are governed by laws. They are governed by standards that say you've got to have a defined rationale that tracks through and that a court can review and take a look at things, evaluating in the balancing test, did right occur? I respectfully posit to you, right has not occurred in this case because there is no justifiable reason for saying on day 1, day 10, and day 20, yes, that's a good reason, and on day 30, and those are obviously wrong numbers, but that the reason's no longer good.
Economics strictly.
Especially the
Okay,
mortgage.
it would appear that he did give you a reason.
That economics weren't valid,
Right.
but there's no reason
Well,
for...
I just want a point of clarification. You stated there was no reason that you felt that was valid. His reasoning is economics, and he has, according to the code of 104.1, the authority to do that, to make that interpretation.
104.1 merely says that he is the authority to render interpretations of this code. What
Right.
what do the terms of this code mean?
And then you also have that other code of 105 point,
Justifiable cause demonstrated.
right.
Now, justifiable cause is what we're all about. And what I've said to you is, because in my history of this project, justifiable cause has been recognized in the same words that we're using now that are rejected. That is an arbitrary decision. You've made one decision one way on one day, and the same facts presented, the same rationale presented, and make the opposite decision.
I understand what you're saying.
Okay.
Mr. Chairman,
Yes.
I would like to say it's not the same day. The three decisions were made at three different times, and the final decision was made, and it was not the same day.
I didn't say
Times-
same reason.
Situations changed, length of times change, and the duration of the time certainly has an effect on the request. And as far as the economics go, I think if we look at interest rates right now, they're at all-time lows. We might see them have gone up in the last week or so, but there was certainly a period of time when we were at all-time lows for financing.
And I would beg to differ with you.
You know,
Okay, if nobody has any other questions, I'd like to open it to public comments. Is anybody here who would like to speak to this? Mr. Foster? Please come up to the podium. Please state your name and your address, please.
Scott Foster, 3 Merrill Lane. I work for the company that's doing this. But I had a question, actually, on what Mr. Vincent said, and it was on the sidebar that you were getting with the 2000-2006 code. Is it my understanding that you said that if the town adopts the 2006 code, any permit that was approved in 2006 would be responsible to meet the 2006 code anyways? Did I?
Correct.
Correct. So realistically, the whole thing that we were discussing there, we would have to do that anyways. Because the permit was granted in 2006, and if we were to begin I don't know, no longer on the council,
Yeah.
have no idea when this is being brought forth to the council. But if the council were to meet next week and approve the 2006 code, any building permit which had been granted by you in 2006 or after would need to follow the 2006 code anyways.
Correct.
Okay, thank you.
Your permit, as it stands, is from 2000, what was the first date?
January 13th of 2006.
Right.
No. Wasn't it prior to that one?
No, that's our first, that's
Okay.
when this
And
permit
that-
was issued.
Okay, I just
That's-
wanted to.
That was issued in 2006, but we have not adopted the 2006 code. We're still working under the 2000 code, so your 2006 application is by the 2000 code. If the town were to adopt the 2006 code, then any permits issued from that point of adoption forward would be from the code adopted
Right.
at that time, whether it be the 2006 or 2003 even, which is not likely to happen, but the 2003 code is available.
I misunderstood.
But the 2006 code will be brought forward to the council for approval.
Okay, we have a public hearing here. Does anybody else would like to speak? Okay, then I'll close the public hearing.
Can I make a motion?
Yes.
I'd like to make a motion to deny the applicant's request for an extension of a building permit for 2 Bennett Way, tax map U4, lot 4-11 in the B1 zone, and support the code enforcement officer's decision to deny under 104.1 and 105.5.
I'll second.
Okay. Any discussion?
May I?
Yeah.
Mr. Chairman, and to satisfy the concerns that the applicant and the attorney have, is just, should we mention that the total amount is the $150, and that the credit shall apply to a future permit being submitted
Do
I
you think-
so amend my motion.
for
Take that as a
consideration?
friendly amendment?
Do you want to give them an option of receiving a credit or just reimbursing the?
Well, I can't speak for the finance office, and
Well, either
I
a
don't know how
credit
that
or a
would work.
reimbursement, depending on town administrator and Don Purnell's, the finance director, what they feel would be justifiable.
Okay, I'm going to ask for that motion to be read again. So I have a clear understanding.
That we deny the applicant's request for an extension to a building permit for 2 Bennett Way, tax map U4, lot 411 in the B1 zone, and support the code enforcement officer's decision to deny under 104.1 and 105.5, and that we request the town administrator in the finance department to decide whether or not the remaining funds of $9,850
$850.
will be either reimbursed or held in escrow until their permit is reapplied for.
Okay. And you second it. Okay.
What if they don't reapply for it? What if the project dies?
Then we get all the money back. The $9,850 would go back.
No, my motion, the amendment to the motion was that the town administrator and the finance director would decide.
No, he's asking if the project is scrapped completely, then they would get all their money back.
Okay.
Is that what your question was? Yeah. All right. All those in favor of the motion, raise your right hand.
Aye.
All those opposed? Motion carries.
We'll be in touch.
Okay, thank you. I have a few other agenda items.
I have one question.
Mr. Bolton,
Yes.
we have a copy of that letter for you.
Thank you very much.
Actually, I found I had an extra copy.
Mr. Chairman,
Yes, sir.
I have a question for Mr. Bolt. Are we to assume from this drawing that these are all going to be California postmodern buildings? Because none of them have rectangles or parallel lines.
I think
They're all crooked. That's not a building plan. That's not a site plan.
That was the site plan as approved by the
Mhm.
Well, I'm telling you, that's not a site plan.
This is yours. This is the latest map.
If you're saying construction drawings, you're absolutely right, it's not construction drawings.
Says it's the site plan.
Yes.
It'll be changed, I hope.
Okay, I'll give you that.
Might have been the printer too.
No, I thought so too, but everything.
Yeah,
around
everything
it
else looks all right on it.
Okay, we do have
looks like
other
somebody
agenda
punched
items,
it
folks.
to Make it look like a
Did you get this?
Yeah.
isometric.
Yeah,
That's
could
completely
be.
separate.
No, I had another one.
I don't think they intend to build like that though.
Gee.
According to whatever the.
Okay, moving on. Thank you, folks, for coming.
Thank you very much.
Thank you.
Okay, let's take a look here. Under other business, anybody have any other business to discuss for the board? None. Okay, I do. Talking with the town planner earlier this week, there are a number of lecture series that are available through LGC, Local Government Center. This one here happens to be for ethics for land use and board members. I've asked her to get a copy, one for each one of us, so we can understand the ethics and what we can talk about, what we can't talk about. As we all know, there's a lot of stuff that's coming to town here, and I just want to make sure you folks fully understand that, what are the ethics and what are the things that we can talk about, what we can't talk about. In addition to that, I received this afternoon from also the town planner. It's also a bunch of publications that might be helpful to this board. What I'm going to do is look through it with the code enforcement officer and the town planner and see if there's something here that would help us in our job also. It might make it easier for us to understand. So look for something in your mailbox coming.
Mr. Carr and I
Yeah.
applied for the junkyard
Oh, did you?
seminar,
Okay.
and it was sold out.
Really? It's sold out.
So they're having another one in September.
In September, okay. And what was the cost of that, remember?
No
With
cost.
no cost.
Oh, it was a free one.
There's only a cost if you sign up for it and you don't show up.
And you, okay, I thought I read there was a cost somewhere, only if you don't show up.
And you have to pay for the cost of the.
And so
Right.
you
And if you
got-
do sign up, well, let me just go on record, if you do sign up and you don't show up, you're paying the cost.
With the lunch.
Huh?
Basically for lunch is
For
what
the
it's
lunch.
for.
For the lunch, yeah, that's basically what it is, for the lunch. Okay, any other discussion? Do you have a motion for adjourn?
I'll make a motion, we adjourn.
Second it?
I'll second it.
All those in favor?
Aye.
Aye. Thank you. All right. I'm gonna give this back to you. Are we off the air, Mr. Quinlan?